Bom dia ao nosso público
Good
brasileiro.
morning to our Brazilian audience and good afternoon to our German audience. Welcome to the third webinar of the STF, University of Münster, on Digital Constitutionalism and Democracy, an international event organized by the Federal Supreme Court together with the University of Münster in Germany. Last year, the Federal Supreme Court signed a cooperation agreement with the University of Münster, and the third STF webinar, University of Münster, Digital Constitutionalism and Democracy, will be another result of this partnership. The event aims to highlight the impact and adaptations through which constitutionalism and fundamental rights are undergoing in the digital age. The opening lecture will be delivered by Professor Alexandre Freire, Secretary of Higher Studies, Research and Information Management of the STF, Doctor-in-Law from the Pontifical Catholic University of São Paulo, and Master in Law from the Federal University of Paraná. Professor Alexandre Freire teaches at the Brazilian Institute of Education, Development and Research, and at the Pontifical Catholic University of Rio de Janeiro. He is a member of the National Council for Innovation of the Judiciary, member of the Executive Committee of the National Network for Judicial Cooperation, member of the Working Group to Improve the System of Judicial Precedents, and of the Working Group on Expanding Access to Justice, Improving the Costs, Fees, Legal Expenses, and Free Justice Regime, all initiatives of the National Council of Justice. He held the position of Deputy Sub-Chief for Legal Affairs of the Presidency of the Republic. At the Federal Supreme Court, he also served as a special advisor to the presidency and is a member of the support group for the STF Internal Regulations Commission and editor of Revista Suprema of the STF. With the floor, Professor Alexandre Freire. Good morning, ladies and gentlemen. I'd like to share with you a very interesting occasion in June '63 when President John Kennedy delivered a historical speech in Berlin. At the time, he spoke German. He said he spoke in German, and until today, linguists are still discussing what he said. I will not make the same mistake, so I will limit myself to Guten Morning and Willkommen. And so with these words, I would like to greet you all on behalf of the Supreme Federal Court and say that it is an honor to welcome you at our court. The topic of my presentation is Supreme Federal Court as a digital constitutional court. The STF during the pandemic, it advanced in terms of consolidating itself as a digital constitutional court in the Western world. This is a result of a very daring decision to improve the digital model that already existed, and also resulting from an initiative started in 2007 when the Brazilian Supreme Court implemented a quantitative and qualitative filter of topics submitted to constitutional review through an extraordinary appeal. This measure was the result of an agreement between the three branches, the executive, the judiciary, and the legislative, with a view to increasing the performance of the judiciary system and also improving its efficiency. The whole set of measures was called at the time reform of the judiciary, or more technically, the amendment of 45 of 2004. So I will focus specifically on the importance of these measures for the court to consolidate itself as a digital constitutional court along the years. So I will share my screen now to clarify the importance of the virtual plenary in the context of modernization of our court, STF. Today, the court operates in two deliberation environments: the in-person, which is actually hybrid or mixed. And why am I saying this? The Federal Supreme Court, part of its sessions are held in person with most of its members, and it can also take place online. And so some members of the court actually participate in person and others participate remotely from their offices or even from other courts, which happens, for instance, with those members that are part of the electoral court, and also from other states and even other countries, such as Judge Barroso, for instance, who participated along the pandemic. He participated in important trials, even though he was residing in the United States at the time. It's important to clarify that in the health measures imposing social distancing, during that time, the judges also adopted solutions that would protect the rights of lawyers. And so the lawyers were able to access the virtual sessions through platforms such as the one that we are using now for this event. Also, the lawyers and legal advisors in general, they were able to interact in general in trials taking place through video conference. And with the reestablishment of normality at the Supreme Federal Court, the judges returned to in-person sessions, but those who are on an institutional mission or for, say, health reasons cannot participate physically, they will participate remotely. Therefore, this is a model that, in my view, has become permanent in the Supreme Federal Court. But at the height of the pandemic, it was actually very important for the STF to address the very serious cases that were submitted, such as the originary civil cases that involved the COVID-19 pandemic. On the other hand, the STF also developed a virtual environment. And so we do have the online deliberation model, which corresponds to around 98.67% of the total of deliberations of the Federal Supreme Court. And this model is subdivided into two. I will explain now. So we have the online virtual environment for general repercussion, the virtual plenary for general repercussion. So this concerns topics that are submitted to the STF, and the court can examine whether the topic is relevant and whether it is transcendent. In other words, whether it has an impact not only on the subjects of the case, but also on the whole of society or a significant segment of society, and whether the topic is relevant from an economic, political, legal, or social point of view. And so the judges examine this important topic in the virtual plenary. And this entails a constitutional quorum for review of the matter. And so for the constitutional review, 6 votes are necessary, but the court is composed of 11 judges. And so in examining or reviewing the topic, we have the participation of the chair and other members. They can vote for the admissibility with absolute quorum. As to the nature of general repercussion, 8 votes are necessary. And this is a constitutional provision. And so if the court understands that the matter does not contain the attributes of general repercussion because it is not relevant from an economic point of view, let's say, the court may reject the matter, but it will require 8 votes.
And they will vote expressively about that matter. In 2010, there was an important innovation in the court's bylaws that authorized the court to analyze the virtual environment, not only for those topics, constitutional or general repercussion topics, but could also reaffirm or stress case law and jurisprudence. What does that mean? The reaffirming of jurisprudence, it means the judgment of merit of the matter addressed in the extraordinary recourse or appeal. But the rapporteur justice should present the background that justifies that the court is actually able to address that theme. Until recently, that was a prerogative of the rapporteur. And when a justice has countless decisions conversion in one same direction, but the rapporteur does not produce this proposal, he could not present this. But because of the recent reform, the justices now have the authorization to propose it. And now that all of that happens in a virtual deliberation environment, because they take notes, they examine the matters related to the nature of the matter, if it is constitutional or infraconstitutional, and then they move to matters related to the attributes of general repercussion. And as to the jurisprudence of the justice of the court, they can propose an immediate decision. And there's an important comment here. In this phase of the judgment, we don't have oral defense or discussions, because it is a jurisprudence. And also the direction of the virtual judgment does not allow for the presentation of memorials by electronic petitioning, and also for clarifications. Why am I saying this? Because oftentimes it is possible that the subjects of the procedural relationship understand that the procedure proposed by the rapporteur no longer has any connection with reality, but it has changed in meaning, or because of a formal change in the constitutional change and with the constitutional mutation process, or because society has evolved its understanding regarding that matter and it would need to be revisited. So there is no time to clarifications as to this matter, except if the attorneys present a request of a hearing and a memorial to convince the rapporteur and the other members of the collegiate board as to the importance of proceeding with the judgment from that perspective. So this is a mechanism that has been discussed in the court so that we can improve this environment, so that we have an easier environment to provide better experience to the users, and it would be more friendly to manage. So this is one experience in the Supreme Federal Court, and the Federal Supreme Court that has aimed to improve this dimension. To our audience and to our colleagues, I'd like to stress the importance of this deliberation environment. In the moment of COVID-19, in which many courts have closed doors, even in the Brazilian territory, very important Brazilian courts closed their doors. The Federal Supreme Court, for having invested in technology and for having improved its virtual deliberation environment, was allowed not only to resolve important issues per video conference, but also to dedicate attention to the collection of the court. And in this historical line from 2016 to 2021, we have proof of how virtuous the court has been in the examination of themes of general repercussion in the virtual plenary. So here we have 52 topics appreciated in 2020 and 62 in 2022, quite a significant number. And we can see here that in 2021, there were 42 decisions in which the court has recognized general repercussion and has examined the topic. And in 25, the topic was denied. And to the colleagues that follow the Federal Supreme Court, this is already a known reality. But to the colleagues that study the courts from a comparison point of view, it is important to understand that this decision doesn't have an impact only in the concrete cases. It has an impact in the whole justice system, because if the Supreme Court decides that that topic has a general repercussion relevant, we can determine a suspension, general suspension of the process, or even delimiting that issue. So the actions would only be admitted until the sentencing and not the execution of the sentencing. But or it can be suspended. The case can be suspended based on the characteristics of the demand. If it is an individual demand, they can suspend the individual processes, but the collective ones continue to process. And the incidences of repetitive judgments like the IRDR can be suspended only for the judgment of processes in the higher courts. So in the level of the Brazilian justice system, we have the higher court of law, which is similar to the intermediate level court in Germany, which would be an intermediate between the Supreme and the higher courts. It's competent to process and judge special appeals and special resources or special appellations, and also special appeals that are interposed, and also homologation of foreign sentences. So this court have an important function, but in a suspension in which you discuss the retroactive suspension has limited the suspension of judgment of the special appeals at the level of the higher court of justice. And then there was an expansion for other degrees of the jurisdiction, but the justice at the first moment has modulated the national suspension only for the court because of a procedural class. This is a very relevant point when we discuss the national suspension of processes. So all of the lawsuits and all of that recurs from the general repercussion recognition. When the court understands that it's not general repercussion because it's infra-constitutional, the court also issues an important message that it would not issue any opinion about that. And this is taken to the STJ, which is the higher court of justice, with these special appeals. And all of that is in an electronic environment. When the court understands that the matter is infra-constitutional, it may not only say that it is infra-constitutional, but it can also state that it should be immediately examined by the higher court of justice with the technique of redirectioning of the process. So you take advantage of that case being in the Supreme Court, and it's forwarded to the higher court of justice. For the colleagues that study our Brazilian justice system at large, it's important to understand that up to very recently, 2015, this was unlikely because the two courts had an understanding that the posing of a special appeal with constitutional matter did not allow for permutation of one appeal to another one. So you couldn't forward these types of appeals. And the same thing happened in the Supreme Federal Court. When it understood that the matter was infra-constitutional, it did not examine and didn't say anything about it. And the decision was based only for the concrete case. From this extraordinary position, the higher court of justice could not just simply examine the matter, but with the reform of the Civil Code of 2015, many of the institutions in that code, like the IRDR, that is inspired in the Buschkenverfahren in the German system, the Brazilian system ended up adopting a model that allowed for this dialogue between the Supreme and the higher court of justice with this technique of redirectioning. And the scholars of civil procedure uh, study this as the permutation between procedural classes. And I go beyond that. In the general repercussion system, the Supreme has not only recognized or denied as themes, but it also examined thesis. When the Supreme Federal Court judges the concrete cases, it establishes a reason to decide, a rationality to decide, reasoning that will be an agenda of conduct, a model to be observed in similar cases examined by the Federal Supreme Court and by the higher courts in the second degree and first degree judges, whether they are federal judges or state level judges. And this understanding is consolidated with the thesis which is established by the Supreme Court. So we have the judgment of the concrete case, the composition of a rationale for that, and the elaboration of a thesis that will be guidance for the Supreme itself, that will be connected to this decision. In that and in other judgments, similar judgments, and also it spreads down to the lower levels, to the other courts with a vertical connection of the precedent. This is an important measure in the civil code, inspired by the British and North American systems of precedents, with the purpose of providing a better soundness and integrity and stability to the decisions. So the precedent systems in the Brazilian model, it does not deter from a cultural improvement such as it happened in the British or American models. They actually emerge from a combination of factors that take into account the legal procedure in the Civil Code of 2015 reform for the general repercussion matter, and also emerges from the authority of the Supreme Court for the establishment of understandings of constitutional matters and precedents for infraconstitutional matters. So in this period of very serious institutional instability because of this planetary global health crisis, the Supreme has judged countless topics of general repercussion. Because of this, these are topics that are social, penal law, and financial tax law. So it established horizons for that, because even though they were based on matters related to COVID-19, the court had full awareness that very serious topics deserved the attention of the Supreme Court. So the court in 2020, so that has examined 134 theses, and in 2021, 65. And if we take the historical trajectory of the Supreme Court from 2016 and 2021, it is very clear the number of decisions issued by the federal court with the purpose of providing legal or judicial stability for topics that relied on the opinion of the Supreme Court. And this follows a line of thought in the court, which is to make the Supreme Court a digital collegiate constitutional court. Why am I highlighting this, Professor Zimmerman? Because when we take a look at the Supreme Court in the last years, we can see that the court has gone through countless academic questionings due to a personal monocratic nature, because individual justices were deciding individually. So the court were allowed, well, this discussion allowed the Supreme Court to solve these criticisms, because now the justices can submit in timely deadlines opinions on important measures or important cases for provisional urgent matters that are submitted to the court for immediate examination. So now a justice can submit a topic to the collegiate environment to be judged in 48, 24, 72 hours. That has reduced the number of monocratic decisions and has given the Supreme Federal Court an opportunity, a historical opportunity, to establish itself not only as a constitutional digital court, but a collegiate digital constitutional court.
So this was a major bet by the Supreme Court regarding its own future, which was precisely the refinement of its technological hub based on the improvement of trials in virtual environments. Now, to conclude my contribution to this event, I would like to show you some data from 5 of April 2022, the percentage of trials in online environment. And so in 2022, we had 98.67% of all the trials in virtual environment. Only 1.33 were in person. And so professors, this percentage, Professor Nora and professors, this is due to highlights or displacements of cases from the in-person to the online environment. And so when a justice the justice can trigger a functionality that will displace the case to the in-person environment. And so after this displacement or this movement or this transfer, they will wait for the opportunity for the trial or calendarizing, so to speak. And so they will then wait for the in-person trial. And so with this significant percentage, 98.67%, you can see that the court is mostly digital for major themes. So it's not only for lesser themes, it's for complex major themes with wide participation of society through amicus curiae and previous public hearings that conferred to the Supreme Federal Court very important elements for decision, especially on sensitive topics that the court does not have institutional capacity to deliberate on. The court often needs to hear society, especially segments that will be impacted by its decisions. And so these are my contributions. I'd like to thank Justice Luis Fux for the invitation. It's a pleasure to participate with Professor Carvalho Filho, Professor Estelita, Professor Zimmerman, and Professor Nora Markert. And so I wish you all a very good day. Thank you, Duncan. We are grateful for the words of Professor Alexandre Freire, and continuing the event, we will have two panels with intense interaction between Brazilian and German speakers. The first panel will have the participation of Professor Frank Zimmerman as speaker and Professor Eloisa Estelita as a debater. Professor Frank Zimmerman teaches classes on criminal procedural law, European and international criminal law, as well as digitization challenges for criminal law at the University of Münster. His main areas of research include European and international cooperation in criminal matters, the interactions of criminal law and the political system, as well as the role of criminal law in the digital age. Professor Luisa Estelita undertook a postdoctoral degree in Germany at the Ludwig Maximilians University in Munich and at the Augsburg University. She holds a PhD in criminal law from the University of São Paulo, a master's degree in law from the São Paulo State University, Júlio de Mesquita Filho, Unesp, and a degree in law from the University of Ribeirão Preto. She worked as an advisor to the minister to the justice at the Federal Supreme Court and holds the position of professor at the Law School of Getúlio Vargas Foundation. To start this first panel, I'd like to give the floor to Professor Frank Zimmerman.
Thank you very much. I'm just trying to share my presentation. Now it should be visible, I hope. Does that work? Could anyone just give me a short sign? Okay, thank you very much. It's a pleasure to be at this event. And so thank you very much for the opportunity to speak to an audience, which certainly is more oriented towards constitutional law topics. And that's why it's a particular honor for me as a criminal lawyer to speak here and to present you some thoughts on the topic deepfakes and democracy. What is the role of criminal law? So this is a topic, which brings up a question of substantive criminal law, basically, but in the light of most recent technical developments that, I think most of us find not only interesting and fascinating, but sometimes maybe also a bit threatening. So let us have a short look at the structure of this presentation before we actually start. It is divided into 4 parts. First, I'm going to say a few words about deepfakes and what challenges they bring about for democracy. In the second part, I will analyze 2 criminal law provisions which might apply to deepfakes. And in the end, we will see that at least to the largest extent, they do not. But 2 criminal law provisions that might be useful in this context. The third part of the presentation is, deals with the draft AI Act of the European Union. And we will see that also there we will find some inconsistencies and that show that this deepfakes topic maybe not has yet been understood or taken into account to the full extent. And finally, I will make some very rough comments on how criminalization of deepfakes could or should like, or maybe how it could or should not look like. So, deepfakes, a new challenge for democracy. It is crucial for every democracy that citizens have access to profound and reliable information in order to make their voting decision. Mass media offer loads of information with little possibilities to filter out non-reliable statements. The consequence is a staccato of constant information that makes it increasingly difficult for citizens, and particularly for those citizens who lack education or simply who do not have the time to consult different media, to identify what is nowadays frequently called fake news. This big topic of fake news actually describes a risk that democratic decisions are influenced and even manipulated. What makes the situation worse is that in the time of social media, so not only mass media, but social media, everybody can disseminate every type of information without being bound by journalistic standards. Thus, it has become very easy to produce fake news, one could say. However, this phenomenon as such is not new, and many media consumers actually have learned to be skeptical towards seemingly scandalous or spectacular news, or also pictures. But video or audio recordings still are considered very reliable. And you could say that an incident that we see with our own eyes, prima facie, seems to be real to us. This brings us to the core of the topic. With technical development and its advances, new challenges have arisen. With artificial intelligence, or AI, it has become possible to create very extremely realistic fake videos and fake audio recordings. And as these techniques are based on something that is called deep learning, the results are called deep fakes. So this is where deep fake comes from, deep learning, and something that has been fake. What is a deep fake? I will use a definition here that I haven't developed myself, but which stems from the European Union Draft AI Act, where we see that a deep fake is considered an AI system that generates or manipulates image, audio, or video content that appreciably resembles existing persons, objects, places, or other entities or events, and would falsely appear to a person to be authentic or truthful. To give you a recent example, well, I guess most of you know who that is. That is Volodymyr Zelensky, the president of Ukraine. And well, a few days after Russia started its war against Ukraine, a fake video of Mr. Zelensky appeared in social media and also in, well, traditional media, a video in which he called his troops and also his citizens to surrender to Russia. And well, obviously it was a fake video, and it was a fake video, a deep fake that was not even thoroughly construed or drafted, because it was very easy to identify it as a fake. But still, this event shows us in which direction things develop. And it may be a matter only of a few years until it is no longer possible to know whether a video is authentic or not. The consequence is that there is an ever bigger danger that also the democratic process is manipulated by deepfakes, especially when they are disseminated shortly before an election. So this is a recent example, not manipulating a democratic election, but it is easy to imagine situations where such deepfakes have a considerable impact on a democratic election. And as this is such a big problem or a very important topic for a democracy, one might have a look into each country's criminal codes in order to find out whether such a form of manipulating democratic elections actually is a criminal offense. And well, I will present you two provisions now. The first one is from the German Criminal Code. It's section 108a. It reads, whoever by means of deception causes another to be mistaken as to the content of the declaration upon casting their vote, or against their will not to vote or to cast an invalid vote, shall be punishable. This is not a translation by myself. I'm not so sure whether it's linguistically perfect, but it has been provided by the Federal Ministry of Justice, so I think we can at least work with it. This offense, which is called deception of voters, is, according to this official denomination, relevant for acts that try to manipulate voters, and it could therefore also be relevant for deepfakes. But let us have a closer look at it, and then we see that it covers three situations. The first situation is that the perpetrator causes a mistake as to the content of a vote. What does that mean? To give you a very simple example, it would be the case that the perpetrator says or creates the impression that a certain person is candidate X, although in reality it is candidate Y and not candidate X. So somebody who votes for candidate Y actually seems that or thinks that he votes for somebody else. And this is a mistake as to the content of their electoral declaration. The third situation, to cast an invalid vote, is also, well, not so difficult to imagine. For instance, a perpetrator could create the impression that it is possible to vote for two candidates at the same election. In some states, this is possible, but let us imagine that in our election, it is not. Then automatically somebody who gives 2 votes to 2 different candidates will cast an invalid vote. And this misinformation, this mistake, will therefore lead to an invalid vote. The second situation is the one that I will focus a bit more on the next slide. It is the one that the perpetrator causes somebody not to vote at all. Well, what is this criminal offense about? When we think about the 3 situations that I have just sketched, then you already see that it's a very precise offense that looks at very specific situations. And if we look at the wording, then we also find, well, a few points which clearly show that it is a very limited, a very strictly restricted criminal offense. So first of all, we see that the perpetrator actually must cause a mistake. That means it must be proven that somebody has had this mistake. And well, as always, when it comes to proving causality, this may cause some problems. The second point is that the provision does not cover acts of deception that merely influence voters' reasons to vote in a particular way. You can see this from the word highlighted in red here. It must be a mistake as to the content of the declaration. So it's not the mistake that actually leads somebody to a certain decision, but it's the mistake as to the content of the voting decision itself that this provision looks at. And well, the last point, against their will, basically points into a similar direction. Now, could this offense have any relevance for the publication of deep fakes in order to manipulate democratic elections? At a first glance, you could say that it might have at least a limited effect. If you remember the second situation, that somebody, due to a mistake, decides not to vote. And I'll give you an example which might actually show a certain relevance of this section 108A. So imagine that person A plans to vote for candidate X because candidate X is the only candidate that represents his political opinion. So far, so normal. But shortly before the election, A sees a fake video in which this candidate X seems to make a racist statement. And therefore, A is so disappointed that he decides not to vote for X. And since she would have been the only candidate that he found convincing, A stays away from the election. This could be a case where somebody, due to a mistake, is, or decides not to vote in the sense of this second situation described here. So at first glance, section 108A might be relevant for deepfakes, at least in this very particular circumstances. But according to the prevailing opinion, this second case, this is the decision not to vote, should be interpreted in a different way. To put it simple, it shall only cover the case that a voter unknowingly misses the chance to vote. So an example would be that due to false news, A thinks that the election takes place a week later and therefore misses the election and has no chance to vote. This is a case that the German legislator had in mind when it drafted the provision like that. And as the law requires a voter to act against their will, you see this also highlighted in red, this interpretation is probably plausible because in the first example that I just gave you, somebody is disappointed due to a deepfake video. This person knows perfectly that he is not going to the election. And you couldn't say that not going to the election is against this person's will. So this shows that probably this provision must be understood in a more narrow sense. And this allows for a, I would say, consistent understanding of section 108A seen as a whole. The provision always requires a mistake affecting the manifestation of voters' will, the manifestation. By contrast, it does not cover mistakes that occur one logical step earlier, when voters still form their will. This restrictive interpretation is clearly what the historical legislator had in mind when it adopted section 108A, because the provision, according to the legislative materials, is explicitly not intended to criminalize mendacious propaganda. So even though, against the background of these new technical developments, particular new risks that deepfakes pose to democracy, even though it might therefore be desirable to have a criminal offense to cover at least certain cases, section 108A is not that offense. And the consequence is that section 108A is without any relevance for deepfakes that influence voting decisions. Things are a bit different when we compare this German provision with its sibling in the Austrian Penal Code. This is section 264. Whoever publicly disseminates false news about a circumstance that is likely to deter persons entitled to vote or to induce them to exercise their right to vote in a particular way at a time when a counterstatement can no longer be effectively disseminated shall be punished. And there is a second paragraph which considers it a more serious offense if false or falsified documents are used in order to create this deceptive impression. Now, what we see when we compare this provision with the German one, then we see that it is broader in two important regards. First of all, it is sufficient for the Austrian offense that a certain information, a certain false news, is likely to deter persons from voting or likely to induce them to exercise their voting right in a particular way. There is no need to prove causation, as in the case of the German provision. And what is also broader here in the Austrian offense is that it is sufficient to induce voters to exercise their right in a particular way. So the mistake in motives that the German provision does not cover is explicitly covered here by the Austrian offense. And therefore it could actually have some relevance for deepfakes. But there's always a but when you say something like that. But we find two other points in this Austrian provision which also limit its relevance considerably. The first one is the requirement that a counterstatement can no longer be effectively disseminated. And in the era of online media, this temporal scope of application is thus limited very much, because it's almost always possible to effectively disseminate a counterstatement. The effective scope of application for this provision, therefore, is maybe one day before the actual election takes place. The second point is that this second paragraph, which refers to false or falsified documents, refers to a very particular, very technical notion. A document is a certain, is something that is able to prove a certain event or a certain circumstance. And it is, or it actually has to be a certain mind declaration by somebody else. And a mere video recording or an audio recording is therefore not considered a document in that sense. For those who are familiar with the German language, the precise translation would be Urkunde. And this is something very particular and not a video recording, not an audio recording. And this clearly shows that also this Austrian provision, although it is broader than the German one, certainly still stems from the analog world and is not really apt for new digital challenges. What can we draw as a, well, intermediate summary or conclusion? There are criminal law offenses which can capture certain types of fake news and to a certain extent also deep fakes. However, also, or even the jurisdictions that have such offenses have their problems with the particular digital challenges of the modern world. Let us therefore now have a look at a piece of legislation which addresses precisely these new digital developments, and that is the draft of a European AI Act. It's a draft regulation of the European Union. And there in Article 52, paragraph 3, we find the definition of deepfakes that I already used in the beginning of the presentation. But we also see that users of deepfake shall disclose that the content has been artificially generated or manipulated. So actually they have to make sure that it's possible to recognize for citizens whether something is fake or is authentic. That looks good, but, and again there is a but, the second sub-paragraph says that this provision shall not apply where the use of deepfake is authorized by law or, I squid a few lines, or where it is necessary for the exercise of the right to freedom of expression and the right to freedom of the arts and sciences. And this shows that the drafters of this AI Act also had their problems with capturing deepfakes. And this becomes even more visible when we look into Annex 3. Now you might wonder, why should we have a look into an annex of this draft regulation? Well, this regulation distinguishes between different types of artificial intelligence technologies. And it classifies them into high risk and low risk categories. And as far as high risk AI is concerned, there is a list in this Annex 3. And Annex 3 says that high risk AI systems, amongst others, shall be AI systems intended to be used by law enforcement authorities to detect deep fakes. The consequence is such a high-risk AI system is subject to obligations for the persons using it. There must be a risk management, a technical documentation. There is a requirement of automatic record keeping, and such a form of high-risk AI system must allow for human oversight. So additional regulation for high-risk AI, that is what this draft AI Act has in mind. And it says, well, this should apply to technology to detect deepfakes. Why that? We find something about that in a recital number 38, which says that AI systems intended to be used in the law enforcement context are particularly risky because their accuracy, reliability, and transparency is particularly important. So this is why the regulation or the draft regulation only considers technology to detect deepfakes as high-risk AI. But given the importance of deepfakes or the potential impact of deepfakes for democratic elections, I think that you should consider to also add technology to produce deepfakes into that high risk category. And that is something that obviously has not been done. In the draft regulation, AI is considered high risk also when it refers to critical infrastructure, like hospitals or transportation systems. But I think for a democracy, also the process of voting and the information surrounding electoral decisions is a form of critical infrastructure. And therefore, I think that this regulation should also consider the production of AI in the context of democratic elections as high-risk AI, with all the consequences that I just mentioned. So risk management, technical documentation, record keeping, and so on and so forth. Now, this was a point of criticism regarding this European piece of legislation. Let us now, towards the end of my presentation, have a look at potential new criminal offenses that could be introduced in order to tackle this problem of deepfakes. So now moving on from just regulating AI, like the European AI Act, to potentially criminalizing certain forms or certain uses of artificial intelligence. I think the common denominator of all suggestions should be that it is legitimate to criminalize the use of deepfakes only where they are likely to influence a voting decision. So not every form of deepfake is problematic. There are deepfakes which are easy to recognize. They are deepfakes which have nothing to do with electoral decisions. None of these deepfakes is, in my opinion, in any way relevant to criminal law. But to the extent that they are likely to influence a voting decision, I think such deepfake technology could be considered relevant from a criminal perspective. Now, taking this as the basis, I think there are three potential approaches to criminalize deepfakes. The first one would be to criminalize the intentional distribution of deepfakes. So forwarding a deepfake video, for instance, might be considered a criminal offense by some, but I think this is not very convincing. If I look at my colleague Nora Markert, who has written a lot about the so-called silencing effect of certain types of criminal offenses, then I think this is also a great problem in this context. If you have to be afraid that something that you share with your followers on Twitter or Facebook or wherever might be a fake video, then you might be prevented from sharing it at all. And this would actually silence the public debate. That is the effect, which I would also consider very problematic here in this context. But this criticism, from my perspective, is mostly relevant only for the intentional distribution of deepfakes. The second approach is less problematic, I would say, because it refers to the intentional production of deepfakes. So if I create a deepfake video of a certain politician, and this deepfake video is likely to influence a voting decision, I think it's not so questionable to make this a criminal offense. This is an approach or a path which is viable from my perspective. A last and final point or final approach, there could also be an idea to criminalize the intentional programming or the proliferation of deepfake technology. So one step earlier, not just producing a deepfake video, but already programming an algorithm or distributing it, selling it to customers, might by some be considered worthy of punishment. I think that would go too far, because somebody who programs such an algorithm normally will not have a particular knowledge what it will be used for. And as I said before, deepfakes are not problematic in many circumstances. They may be just fun, they may be a form of art, also, well, in certain contexts, a form of science. And that's why I don't think that programming an ever realistic algorithm in order to create deepfakes could or should be made a criminal offense. But at least for the second part, the intentional production of deepfake videos or audio recordings, I see a certain room for criminalization. Probably I've been talking much too long now, but it's my pleasure to accept now the questions or the comments by my dear colleague, Eloisa Estelita, whom I know for a very long time and whom I appreciate very much. So Eloisa, the floor is yours, and thank you very much in advance.
Muito obrigada. Bom
Thank
dia.
you. Thank you. Good morning to all of you. I'm going to speak Portuguese slowly so everyone can keep up. I would like to thank Justice Luis Fux for the opportunity, the invitation to participate in this session, which is so relevant, especially in view of what we are experiencing in Brazil. I would like to greet my colleagues on this panel, especially Professor Zimmerman, whom I admire greatly, and with whom I actually have a friendship and also love for Augsburg, the city where he lives. And he has brought us important inputs regarding crimes provided for in German and Austrian legislation, countries that have consolidated democratic systems with wide access of the population to broadband and data packages. In other words, access to reliable sources of information, including for the recognition of deep fakes, or at least accessing information about the production of deep fakes. However, the Latin American scenario has some peculiarities. I'd like to point out two, and then hear Professor Zimmerman's views. In most of Latin America, democratic systems are very young, still some of them even undergoing instability, which might be the situation in Brazil now. We still have a very vivid memory of the dictatorship, reflected in the broad protection that the STF has been conferring to freedom of expression. So a paradigm in this line of action of the Supreme Court was given by DPF 130 with a famous sentence by Justice Carlos Brito that freedom of expression must be on the table of democracy. That's one side. The other side, a technical issue, not only technical, but one related to access to broadband and a good data package. It's very expensive in Brazil and inaccessible to most of the population, or a major part of the population. So most users and voters will only have access to apps whose data is not discounted, right, from their plans. So I'll explain. In 2019 data indicate that 98% of the population will access the internet through their mobile phones. Of these, 58 access the internet only on their mobile phones. And from these 58%, we have classes D and E. 80% of D and E, the lowest and most numerous, concentrate access to the internet only through their mobile phones. On the other hand, the zero rating practice is a business model in which the operator, after the client, the customer, exhausts the data, will allow the user to continue accessing certain services and apps free of charge. It's not a coincidence that Facebook, Twitter, WhatsApp have zero rating agreements with operators in Brazil. concentrating the use of clients with reduced access, they mostly are limited to these apps for information and for communication, leading us to a chronic aspect of the problem in Brazil. Most of the population accesses internet through mobile devices. Most of the population will purchase prepaid packages, and this leads to massive use of apps with zero rating, channeling access to information to the zero rating apps. In other words, Facebook mostly, and also channels the messaging services contemplated with zero rating, WhatsApp and Facebook, because you can access Facebook within zero rating. And so that reveals the informational control over most of the Brazilian population. This control could be addressed through the implementation of artificial intelligence for a detection of fake news, as Professor Zimmerman just mentioned. But this would have no effect on messaging systems, which are today the main form of dissemination of fake news in Brazil. And the use of artificial intelligence for the control of fake news in messaging services could only be implemented at the expense of severe restrictions to the right of access to communication. So allowing apps and public authorities to access the content of messages. And that would entail surveillance and lack of privacy. The Supreme Court has already expressed itself on this matter regarding encryption in WhatsApp. So the remedy would kill the patient. And in addition to this trap, another trap is the business model of social media, inducing low quality of content that is produced, because the remuneration of economic agents is directly proportional to the size of the audience and attention that is garnered by these programs. So in face of this, Professor Zimmerman, I would like to hear your thoughts on 2 points. How do you see the role of criminalization of fake news, or the difficulty in criminalizing fake news in countries that have a young democracy, and your thoughts also on whether changes in access of low-income population to better data packages and also better messaging services, whether this would be more effective and more comprehensive than direct regulation, especially penal criminalization, especially in the context of a young country in the process of consolidation of democracy. So I'd like to give the floor back to you. It's a huge pleasure to join you in this session. I hope that we will soon be able to do so in person.
Thank you very much for these brilliant questions. Yes, I think it's always most precious to contrast the own personal view with the one from different countries, different jurisdictions, which might have a totally different history, as is the case with Germany and Brazil. And yes, I think that the topic of potentially criminalizing fake news, and well, as you will have recognized, I'm rather skeptical, and I pinpointed just a certain circumstance where I think this might be a path to choose. But when it comes to criminalizing fake news, then you could, of course, argue that for young or less stable democracies, it is even more relevant that the population develops a certain idea of reliable information and has access to authentic information. So you could say that the need, the pressing social need for legislative action, also in the field of criminal law, is even bigger. And I think when you add to this what I said before, that just the distribution of deepfakes should not be criminalized, then this is a very important complement, because just criminalizing the production of deepfakes actually targets the persons behind, targets the persons who try to manipulate citizens and voters. And that is particularly in a country where there is a big divide between the powerful and the poor. I think something that one could at least think about. The second point that you mentioned, I think it referred to the service providers and their role, and whether regulating service providers could actually also be a possibility. Yes, absolutely. I could have mentioned, but I was too long already. But I could also have mentioned a second European piece of legislation later, the Digital Services Act, which tries to introduce specific rules and regulations for service providers, particularly for the biggest ones. So the big providers like Facebook or Twitter and so on. And this regulation also aims at introducing sanctions, not necessarily criminal sanctions, but pecuniary sanctions against such service providers. So I think sanctioning on that level also is certainly something that should be taken into account as a possibility. Thank you. I do not know how we continue. Do you want to answer maybe, Luisa?
I'm just want to say I'm very glad with your answers. Thank you. I think we give the word back to our host.
Exactly. Thank you very much, then.
Agradecemos as participações do professor Frank Zimmermann
We
e
thank
da professora
for the participations of Professor Franz Zimmerman and Professor Eloisa. We'll now start the second panel of our webinar. We have Professor José Carvalho Filho as a speaker and Professor Nora Markert as a debater. Professor José Carvalho Filho has a PhD in constitutional law by Marseille Université. On France, he has an internship on postgraduate degree in Salamanca. He's a professor of the Brazilian Institute of Public Law, and he acts as a researcher at the Coordination of Judicial Research at the Secretariat for Higher Studies, Research and Information Management of the Federal Supreme Court. Professor Nora Markert teaches public law and human rights at the University of Münster. She holds a postdoctoral degree in law from Humboldt University in Berlin and a master's degree in international peace and security from King's College in London. Her main areas of practice are constitutional law, human rights, international refugee law, and gender. She is vice president of Gesellschaft für Freischaffung, a non-governmental organization specializing in strategic litigation on constitutional rights. Professor José Carvalho Filho has the floor to start his panel. Hello, good morning, everyone, and good afternoon. It is my great pleasure to be a part of this very high-level event organized by the Supreme Court and the University of Münster. Thank you, Dr. Luis Fuchs, for the invitation, and also for the Institute of Research and Management of Information, our Secretary, Alexandre Freire, coordinator Viju, and the manager of practices, Dr. Guilherme Neas, that have made this event possible. I would like to congratulate the participants of the previous panel because they have elevated the level of this webinar and have given myself and Professor Nora a great responsibility to keep the level very high. We've learned a lot from your interventions, from Professor Frank and Professor Estelita, addressing the reality of the Latin American countries, and I'll try to contribute to this debate by presenting a little bit of the Brazilian reality in the facing of the challenges that the digital constitutionalism needs to face in the digital era of democracy. And I'll try to do that presenting to our foreign guests some contributions that have been provided by the judicial branch in Brazil. So basically, In this webinar, we have a few operational concepts, which is digital constitutionalism and democracy, and I would like to address these operational concepts. First, about democracy. Democracy can be defined in a more restrict and formal sense as the government of the majority, or an elections-based democracy, and also in the broader sense, a substantial and material, which is where there is also respect for fundamental rights and democratic institutions in the material meaning. But the fact is, with the development of digital technology, this notion of democracy started to be affected by the new forms of social interaction. So the form through which society interacts today digitally creates a lot of impacts, both positive and negative impacts. And some of these negative impacts might affect our democratic regimen. First, I'd like to address some of the positive impacts of the digital era. There was an expansion of access to information, and this is very positive. We've also seen an agility in the mechanisms of inspection and verification of the electoral process. Social media and the internet has provided for social agents to have better coordination and articulation to claim rights like civil rights, political rights, and even social rights, to claim these rights and the classic institutions, and also get organized by means of strategic litigation. And we also had the strengthening of constitutional jurisdiction due to the fundamental rights. And also Brazilian courts have also gone through a digitization process with development of the electronic judicial process and the virtual plenary of trials in courts that was brilliantly presented by Professor Alexandre in the beginning of our seminar. These technological innovations allowed for the improvement of the digital procedures in courts, but this improvement also brought forth some negative impacts, some of which were already approached. Professor Frank Zimmerman talked about information pollution. If on one hand we have an expansion of access to information, which is quite positive, there is too much information of questionable quality and content. We have mass messages of fake news, manipulated messages, manipulated information, and this is very complicated for a democratic regimen, because depending on the way these are manipulated, there might be political compromise. And I'd like to remember the case of Cambridge Analytica, a company that has influenced electoral process in many countries, African countries, European countries, and started to be known by the scandals of interfering in the electoral processes in terms of Donald Trump, in the case of Donald Trump's election, and also in the Brexit. Cambridge Analytica doesn't exist anymore. If you want, you can research to look up those scandals. But it created a problem in the democracy, which is the possibility of directing the voters and compromising their autonomy to make their decisions in the elections. Other negative impacts is that due to the exercise of freedom of expression in the internet environment, there was an intensification of some hate speeches regarding some vulnerable groups and or democratic institutions. And these are problems that must be faced by constitutional law currently. And this matter of freedom of expression is also associated, and it also exacerbates the problem due to the indefinition of the liability of internet providers for content produced by third parties, because the speeches, the freedom of expression is exercised by citizens, but those who store this contents are the internet providers. So we should discuss the liability of the internet providers in the control of such content. Should they ban or restrict some contents, limiting freedom of expression, or should they leave the content there, even though there is a compromising of the rights of some people in some other countries. So this is a problem that has risen in the democratic countries due to the digital technologies. So to face these problems, we have started to develop regulation mechanisms, especially with the use of constitutional law. And this is where our second operational concept arises, which is a digital constitutionalism. So digital constitutionalism is developed as a branch of contemporary constitutional theory aimed at protecting new rights and protecting the democratic regime itself in the digital age. So the state, through the legislative, the executive, and the judiciary branches, protects new rights like the ones related to personal data, access to technology, complex claims of rights to be forgotten and de-indexed, and fighting misinformation, and so on. In my presentation, I'll try to focus on a few contributions that the judicial branch has provided for the facing of these problems in terms of contemporary constitutionalism or digital constitutionalism. And I'll also address how this has helped in the facing of the negative consequences of new technologies. And I have prepared a few cases that are emblematic. The first one is the Supreme Court case after the pandemic, in which the Supreme Court recognized that informational self-determination is an autonomous fundamental right. This is not explicitly expressed in our Constitution, but the court recognized it as an explicit right. And in this case, it was a normative act that was issued by the President of the Republic in Brazil, determining the sharing of data from the telephone company users with the Brazilian Institute of Geography and Statistics. So this act, which was a provisional measure, just did not establish the purpose of the sharing of data, nor adequate measures for the protection of the data that was shared with the IBGE, the Brazilian Institute of Geography and Statistics. Due to that, the Supreme Court has established the inconstitutionality because it affected the informational self-determination of the citizens, as well as the proportionality principles. And this is a case which is quite relevant in the addressing of these contemporary problems deterring from the digital era, because in addition to the Supreme Court being able to stop or prevent an arbitrary treatment of data in the Brazilian case, there was the first time that informational self-determination was considered a fundamental right, and this became paradigmatic for other problems. We have many other issues that will be faced by the court and will take into account this fundamental right, which is informational self-determination. So that was the first contribution that was given by the Brazilian reality, which is the recognition, once again, of this fundamental right to informational self-determination. We have some important contributions regarding the elections democracy, the electoral democracy. We have in Brazil a specific level of justice responsible for elections, which is the electoral justice, which is based on the Superior Electoral Court, and it has a normative competence to issue rules in terms of elections procedures. In this context, the Superior Electoral Court has issued resolution in 2019, resolution 23-610, amended by resolution 23-671, to discipline electoral propaganda, electoral advertisement on social networks. And they established, for example, that mass messages are, as a rule, prohibited, as well as the placement of propaganda with mass messages. Is also prohibited to issue or to activate mass messages with the objective of degrading or ridiculing candidates, as well as the dissemination or sharing of facts that are known to be untrue or seriously out of context that affect the integrity of the electoral process. This is an attempt to fight misinformation or fake news. Due to this ruling of the Electoral Court, we have some rules that serve as a parameter so that we can make the control and oversight of the electoral propaganda in social media. And this disciplining of, if this is not respected, we can hold the perpetrators liable in civil matters, in electoral crimes, because they can be excluded from the elections process, and also as a criminal offense. So this is a second contribution of the judicial branch in Brazil that seems to be very relevant in the facing of the contemporary problems of the digital era.
o famoso caso do
Sorry. So the third case that I would like to share is the fake news inquiry in Brazil. And so to explain this, I need to provide some context. The Supreme Federal Court, it controls the constitutionality of public acts in Brazil very intensely. And so when we are facing a context where several normative acts are issued in violation of the federal constitution, several of them will be declared unconstitutional by the Supreme Federal Court, because there are several means of access to judicial review in Brazil. And so since the current government took office, several acts of the Bolsonaro administration and the National Congress have been declared unconstitutional by the STF. Thus, an image was created that the court, which is actually defending fundamental rights, has become an enemy of democracy for declaring unconstitutional those acts undertaken by representatives of the people. And so tension between democratic institutions was created in Brazil. And this tension exists in several countries as a natural consequence of jurisdiction. But because of the exploration of fake news, many decisions of the Supreme Federal Court have been distorted or placed out of context in order to create a bad image of the court and generate rejection by the population regarding this institution. And so fake news were actually used for the purpose of affecting the image of the Supreme Federal Court. And this generated so much impact in members of society that we started to see the organization of certain groups on social media attacking not only the court, but each of the justices individually. Investigations actually identified attempts at attacking not only justices, but their family members as well. So in this context, we had no instruments to fight this type of attack against democratic institutions. One of these instruments is actually the fake news inquiry, which was established by the Supreme Federal Court to investigate attacks against the courts, especially through sharing of fake news. It was established during the presidency of Justice Dias Toffoli, and the rapporteur is Alexandre de Moraes. And so it was greatly criticized for not being the function of the court to conduct inquiries. And so the fact that the court itself established the inquiry could undermine the partiality of the judges, which will have to arbitrate conflicts related to the use of digital technology. But the fact is that this innovation in the judicial order can also be understood as defensive democracy instrument. It is an innovation developed by the democratic institutions so that they can protect themselves. And regarding this specific aspect, I would like to end with a term used by Justice Gilmar Mendes in his presentation of SAE talks on digital constitution, which was held about a month ago here. He said that this fake news inquiry represents a break on the skidding of the democratic system. Of course, all these innovations cause certain perplexity, but in the context of major violations and attacks against democratic institutions, it was something created here in Brazil, and somehow, as Justice Gilmar Mendes, it has represented a break on the skidding of the democratic system.
Já caminhando agora mais para o final da minha apresentação,
So another case that I would like to address, and that Professor Eloisa Estelita mentioned, is related to the limits and possibilities of the exercise of freedom of expression on the internet. Each citizen using the internet can exercise their freedom of expression, and the internet provider stores this content. But when the content violates fundamental rights of other people, of vulnerable groups, and represent attacks to democratic institutions, we need to think about how internet providers who store this content can contribute to the maintenance of the democratic regime and preservation of democracy. It's a problem that occurs not only in Brazil. We have today more liberal systems, such as the US system, which privileges the exercise of freedom of expression, establishing few liabilities on internet providers, and others, such as European countries and even Germany, establishing greater liability on internet providers so that they will effectively filter the manifestations on the internet in order to protect the rights of other people as well as the democratic regime. Now, coming back to the Brazilian reality, this issue was temporarily arbitrated by the legislative branch through the institution of the civil liability framework of the internet in Brazil. Basically, Brazil elected the judiciary branch as an intermediary to arbitrate conflicts between the limits and possibilities of freedom of expression. So in Brazil, we elected the clause of jurisdiction reserve for this content produced by third parties on the internet, establishing that internet providers are not responsible, are not liable for damages resulting from content generated by third parties. If after a specific court order, it does not take measures to, within the scope of technical limits of its service and within the period indicated, make the content identified as infringing unavailable, except for the legal provisions that determine otherwise. And so this has been used, this principle has been used in conflict settlement. And so there are cases where this is. So when we are seeing cases of pornographic revenge, for instance, it is enough to issue an administrative order. And the jurisprudence of the Higher Court of Justice here in Brazil established that when we are seeing a violation of the rights of children and adolescents, then this clause of reserve of jurisdiction is inapplicable. So, but these are exceptions. But this transitory measure that was established by legislators is being the object of discussion within constitutional review here at the Supreme Federal Court, because the right to image, the right to honor, and non-discrimination, offensive non-discrimination, they are all provided for in the Constitution. And there is a higher degree of hierarchy than the civil framework of the internet in Brazil. And so many citizens claim that when we established this reserve of jurisdiction, this made it more difficult to defend fundamental rights of people who are attacked in the digital environment. And so this discussion is still open at the Supreme Federal Court. It's topic 987 of general repercussion, which refers to review of constitutionality of the civil framework of the internet. And so there are many other difficulties that we are facing in Brazil and the world. Unfortunately, I cannot address all of them in the time allotted to me, but another very relevant topic related to criminal responsibility and investigation, the investigation as presented by Professor Frank, is related to the request of data from internet operators. So this request must be issued through a judicial order within the jurisdiction of each state or through international cooperation agreements, given that the headquarters of internet providers can be located abroad. And so this also is going to be analyzed by Supreme Federal Court in the Declaratory Action of Constitutionality 16. And it is also something that is being faced by other countries. And finally, to conclude, in most of these problems, issues that I presented, resulting from the use of digital instruments, we see violations of political and fundamental rights, but all fundamental rights can be affected depending on how the internet is used. Professor Estelita has already addressed the topic of digital exclusion, those who are excluded digitally and don't have access to data. According to her explanation in the context of Latin America, these are more vulnerable and more susceptible to attacks against their decision autonomy during electoral processes. But digital exclusion also leads to violation of social rights. During the pandemic in Brazil, while public schools and universities were closed during the most severe moments of the COVID-19 pandemic, private institutions adjusted to the new reality of social isolation and maintained their operation. And so those with more financial resources were able to continue exercising their right to education, while those studying in public schools and universities, their access to education was hindered. And so we have to think of digital exclusion as one of the major challenges to be addressed by digital constitutionalism. So these were my inputs, more about providing context than providing answers, because we don't have in compared a law or in Brazil. And so having made this initial presentation, I would like to give the floor to my colleague participating in the panel with me, Professor Dr. Nora Markert.
Yes, thank you very much, dear colleague, for your very rich presentation. I will do my best to do it justice in the short time that we have, to also leave some time for you to respond, because I'm very interested in your perspective on the few points that I will try to raise. So you spoke about a very broad spectrum of problems that we encounter in regards to sort of what you've aptly called digital constitutionalism and democracy. And I will only focus on one of these problems, namely the question of hate speech and liability of platforms for hate speech content. It is something, and I think that provides a nice bracket with the presentation by Frank Zimmermann, something that in German law very much depends on criminal law, because any ways of countering hate speech or even pursuing civil lawsuits for damages depends on whether the act of speech actually constitutes a criminal offense. And so that would be libel, for example. So we do have in German law the Netzwerkdurchsetzungsgesetz, so the Network Enforcement Act, which obligates platforms or providers to take down certain content, but only if that content constitutes a criminal offense in this way, and it's limited to certain crimes. The same goes, though, for any civil damages suits, because if I am trying to bring somebody to court over an act of hate speech against me, I will only get information on that person's identity from the provider, which I need to bring suit, if the conditions of this network enforcement act are met, and so again, if there is a criminal offense. That severely limits my ability to counter hate speech and to use the courts in this respect. And I would like to highlight a couple of things that I think are interesting from a constitutional law perspective. So in German constitutional law, whenever the courts are reviewing, or when the Constitutional Court is reviewing a criminal decision, or sort of the decision of a criminal court that something can constitute libel, it will have to balance two rights: the right to freedom of expression on the side of the speaker, and then the right to sort of the protection of the personality of the victim of this act of speech, which is based on that person's dignity and sort of in the form of their personal honor. So this balance will have to take a lot of individual considerations into account, but it remains so far a balance between sort of freedom on the one side and dignity on the other. And it seems to me that there is a sort of a gap or a blind spot there, because hate speech doesn't simply affect the dignity of the person immediately addressed. In the conditions of sort of a digital democracy, it has very large sort of lateral effects on other people possibly belonging to the same group, because a lot of hate speech is actually discriminatory. So it is directed against societal minorities, ethnic minorities, women, LGBT persons. And while it will certainly have an impact on the person addressed, other people will also be listening, and they see what happens if one of them speaks up and what that person will have to endure. In fact, the German Constitutional Court has already addressed this as a problem for democracy, because in it passed a number of recent small chamber decisions in 2020. And it also addressed sort of the problem that this poses in getting people to run for office, because we usually expect people running for office or sort of public officials to, take a little more criticism, because criticizing power or those in power is an important function of freedom of expression. And there must not be too much regulation of it, because this is important. And sort of if you are responsible for policies that people disagree with, then there must be a possibility for heated debate also. But this has gone so far, also leading to, in fact, an assassination of a politician that was speaking in favor of the integration of refugees in the wake of 2015, the refugee protection crisis in Europe. This has gone so far that it is, in fact, difficult to get people to run, especially for local municipal offices, where they're often met with massive, sort of, as we call them, pardon my French, shitstorms of hate speech, and then sort of pull out of these offices. So this is a problem, of course, for democracy, especially if minority voices are being pushed out from public forums, because people are in fear of these kinds of repercussions. So if, as the Federal Constitutional Court in one of its very early and very influential judgments, the Lüth case, where it first talked about the horizontal effect of fundamental rights, there it said that it's a life element of the liberal democratic state order that there is an ongoing struggle of opinions that are being voiced in equal freedom. So freedom is only freedom in democracy if it is actually equal freedom, and if minorities also have a possibility to participate in the debate. And I was extremely interested to hear how sort of these problems in the digital sphere are now being addressed by the Supreme Court of Brazil. And I would be very, very intrigued, of course, to hear whether this equality dimension is maybe something that is being discussed either by the court or in constitutional scholarship in Brazil. And maybe just two final points. on the role of the courts. Because one of the ongoing debates over our Network Enforcement Act is that the role of the platforms themselves. Because of course it is very burdensome if I have to go to the courts. It is costly, it takes a long time, all this while the post is up, I may have to go through several instances, I may need an attorney to help me do this. I may first have to go to a civil court to get the information on the person who's actually behind this whole thing. It's a nightmare, which means that a lot of people are actually not enforcing their rights in the courts. However, having more direct responsive mechanisms with the platforms means that there is a democratic problem, because these platforms are now making judgments over fundamental rights balancing without being, in fact, courts that are mandated to do this kind of balancing, and there is very little review. There is one suggestion in how this could possibly be addressed, to have the suggestion is called a Digital Violence Protection Act, modeled on the Domestic Violence Protection Act, where you can push the abuser out of your apartment, to have a person's account suspended if it's been known to produce hate speech, because going after each individual post is a very inefficient, again, way of prosecuting things. And an additional measure included in this suggestion is to allow the poster, sort of the speaker, to remain anonymous during the procedure. So they will get a notice that they can get active in these proceedings and challenge the ban of their account. But if they do not wish to do so, they will remain anonymous in the proceedings, and they will not have to join these proceedings. And finally, of course, this raises the question of whether platforms themselves should have some sort of fundamental rights responsibilities if they're as large and as influential as Eloisa has pointed out. So if they have a state-like level of influence, whether they must not also be bound to certain fundamental standards. In German constitutional jurisprudence, we've had a certain move in that direction with the stadium ban decision, where a ban from all major league football stadiums was reviewed by the court, saying that it cannot be arbitrary and reasons must be given and there must be a right to be heard, so fundamental procedural rights. And of course, this begs the question whether the same would maybe hold for Twitter banning a person like Donald Trump or any other person from their system in Germany, whether there would also be some kind of review. So I've talked way too long. I'm very much looking forward to your response. Thank you.
Obrigado, professora Nora. Foi uma intervenção.
Thank you, Professor Nora. This was a very interesting intervention that has really added a lot to what I said, and the other professors as well. And this only comes to show that it is impossible to deplete these discussions about this topic here in Brazil and in Germany as well. As I said in the end of my presentation, this is a topic that we can easily raise a lot more problems than come up with solutions. The solutions that are being developed are kind of laboratories in the respective countries. So the countries are trying to find, experimenting and trying to find solutions, but they're not always perfect. And I would like to react initially to your comment as to the difficulty of access to justice in the European context that is costly and it takes longer. The Brazilian reality is a bit different because we just had a great expansion of the access to justice. We have free justice system and we have free prosecution services, so access to justice. So maybe because of the Brazilian reality, the clause of a jurisdiction reserve was established as a solution, and maybe the solution was seen as something adequate for the Brazilian reality, but it's not. It may not be adequate for other countries. Even for the Brazilian reality, is already being questioned. But in terms of the conflict between freedom of expression and the dignity and that balance, or the fundamental rights of individuals, we really don't have a ready solution for that. And I don't think any country in the world has that solution. In the United States, they tend to privilege freedom of expression. In other countries, there is more restrictive. They are more restrictive in terms of the responsibilities of the internet providers. And all of the approaches have positive and negative aspects. And Professor Eloise said something very interesting when she said that excessive regulation of freedom of expression may make it impossible for people to manifest their opinions, and that is not good for the democratic process. So it's the silencing effect that was mentioned by Professor Zimmerman, and it's also cause of fear for some candidates not willing to participate in the electoral process any longer. So we cannot prevent people from participating in the social networks because that is inherent to the democratic process. On the other hand, I don't think we can let things run loose, because here in Brazil there's a very popular saying that states that internet is the land without law. It's the lawless land. So we don't know, for a long time we didn't know how to address offenses committed in the internet. Now our challenge is to regulate it by law and try to find a balance between the exercise of freedom of expression and the fundamental rights. The method we've adopted in Brazil so far was the jurisdiction reserve, but this is part of a process. So it's an additional step, but it's not an end in itself. It's yet another step in the fight to face the challenges of contemporary constitutionalism. Just out of curiosity, you asked about the contributions of the judicial branch, and that the judicial branch could give Brazil in terms of aggressions to vulnerable groups. We have a court which is very active, and it's a level of defense for the vulnerable groups. And I can mention countless cases to protect Black individuals, LGBT individuals, women, indigenous groups. I'll mention just two cases that can come to mind, in which the court manifested about interference so that there is a better participation of the vulnerable groups with the establishment of quotas for quotes for women and reserves of position, because here we have an electoral quota in which 30% of the proportional positions have to be for the opposite sex. And in practice, that is means women in Brazil. But what happened in practice is that we had this 30% to provide for a formal criteria, but the women had no agreement with the political party, so they had no real chances of getting elected. So the Supreme Court has issued a decision stating that there should be a proportionality between money, time of television, and the number of feminine candidates, so that there is competitiveness. And recently, the same rationale was adopted in Brazil for candidacies of Black candidates. So when we have Black candidates, that must be equally proportional in terms of funding and time of television to the number of candidates. So these are a few contributions that do not solve all the problems, but they help. Here in Brazil, we usually say that in the last elections for local representatives, a transgender woman received the most female votes in Brazil. So this phenomenon of the rejection of the participation in the electoral process, in my understanding, is not something that exists in Brazil, because that decurs from one of the positive impacts of the internet, which is to allow for the coordination and articulation and presence of these social groups so that they can be present. So they see so many violations that they need to be present in classic political institutions, occupying the spaces of power, or go to the legal branch by means of a strategic litigation. So in my opinion, I think that the Brazilian reality is a bit different at this point. And as to the liability of the providers, just to finish, because it's approaching lunchtime in Brazil, and we haven't had lunch yet. So I'll be fast. So as to the liability of the platforms in this webinar, in which Minister Gilmar Mendes participated, organized by the Secretariat of High Studies. I think it was very interesting to see this point and to listen to this point about the horizontalization of fundamental rights, because we study classically the subjective dimension of fundamental rights and the objective dimension of fundamental rights, but always with this relationship between the state and the individuals, the citizens. Even in the objective sense, the state should look at fundamental rights as the guiding principle of the conduction of public policy and regulation. But we talk about the objective dimension of horizontalization, but for people in hierarchical situations in private law, in civil right, in commercial, in trade law. But now we need this horizontalization for people that at the private level have a vertical relationship.
So it's a new definition of horizontalization of fundamental rights, and we need to take this concept to discussion when we analyze the liability of digital platforms, because if we don't see these platforms as major and powerful entities that also have major responsibility, we will continue allowing violations of fundamental. The path that we can follow in our discussion is to deepen everything we've already developed regarding the horizontalization of fundamental rights, and that citizens are also holders of fundamental rights, not only before the state, but also before these major digital platforms. So with that, I conclude and give the floor back to our Master of Ceremonies. We are grateful for the participation of Professor José Carvalho Filho and Professor Nora Markert. As we approach the end of this inspiring webinar, the third and last in a series resulting from a joint effort by the Federal Supreme Court and the University of Munster, we will hear the closing remarks of Professor Alexandre Freire, Secretary for Higher Studies, Research and Management of the STF. Information. Professor, you have the floor. Translation, apology. Please, your audio, Professor. Thank you. Dear professors, dear researchers, dear audience that follows this live, it is with great honor that I close another event held between the STF and the University of Munster. This third webinar, Digital Constitutionalism and Democracy, is another fruitful result of the international agreement signed between these institutions. The era of technology and modernization that we live in has not only required the constitutional courts to take a new look at fundamental rights, but also presented us with new paths and possibilities for partnerships, which, in spite of seeming distant in the past, today they diminish our borders and bring us closer, even if online. Together, we have built a high-level space for debate and knowledge exchange, in which we bring together brilliant professors, researchers, and jurists from both countries. It is here in our events that we address challenging issues such as the impacts generated by COVID-19 on fundamental rights, the theme of our first webinar, and also when we discussed in our second meeting the important role of counter-majoritarian protection exercised by the constitutional courts. This space has provided us with a chance to learn from the different experiences that both countries face in relation to access and protection of people's fundamental rights, both amidst the pandemic that affected our peoples and in the digital sphere that signals the need for a new look at fundamental guarantees. Here, creative and valuable knowledge is added that contributes to the qualified development of the applicability of justice and that keeps the eyes and ears of this court open for thoughtful dialogue with the members of the national and international academic community. I hope that this series of international events will be just the beginning of our journey together with a long-lasting agreement between both institutions that will yield more fruit as or even more prosperous than the ones we have reaped so far. The success of this partnership is evident not only through the great debates already mentioned with the presence of distinguished professors, but also because very soon we will welcome here at the STF the honorable visit of a professor and researcher of the University of Munster, Dr. Niels Pettersen, who was on the part of the WWU, largely responsible for this technical cooperation agreement. In addition, another fruitful symbol of this technical cooperation agreement is that we will soon welcome an exchange student from the University of Munster to carry out research in the field of constitutional law. So this consolidates the mutual interest of both institutions in maintaining a relevant space for the exchange of academics and civil servants, and also for the production of fruitful research that helps in the production of diagnosis on constitutional jurisdiction. It is for these and other reasons that the agreement signed by these two institutions has a very special meaning for the STF. It was one of the first to consolidate the court's deepening interest in the development of innovative scientific research in the construction and dissemination of academic dialogue, signed with internationally renowned training centers. This measure, of course, leads us to a stronger relationship towards improved governance and innovation at the Federal Supreme Court of Brazil. It is therefore with enthusiasm that I wish for more international initiatives and agreements to be implemented so that we can continue building new possible paths for the evolution of the legal field, its institutions, and democracy. I warmly congratulate the panelists, debaters, and staff of the University of Munster and the Federal Supreme Court through its General Secretariat and its Secretariat for Advanced Studies, Research, and Information Management, who spared no effort to materialize this pioneering initiative of internationalization of the dialogue with the international scientific community and to maintain this channel that is so valuable for our institutions. And of course, I must pay homage to the ceremonial office of the STF and the communication secretariat of the Supreme Court, our tireless partners in these major events that we hold. Also, I would like to publicly acknowledge Justice President Luis Fux, who is very enthusiastic about these projects, and also for the development of knowledge in the scope of the Supreme Federal Court. Auf Wiedersehen. We thank the speakers and debaters for the rich exchange of ideas, and we also thank our audience. With due authorization, I declare this event closed. We wish our audience, both local and international, a good afternoon and a great weekend.